A very short petition will may I just place the relevant portions. Paragraph 5 and 6. আমাকে ঠিক মতো পড়তে দাও, বসো। চুপ করে বসে হেল্প করবে। Your petitioner state on scrutinizing the merit list, several discrepancies, illegalities have cropped up. Several candidates who have obtained low academic scores have somehow got very high scores in the written examination. Such instances are given below. Then, next page. It is germane to mention here that these are only a
These
few
are waitlisted candidates or
Yes.
in the original merit list?
waitlisted candidate without in the original selection and some empanel.
Yes, please refer to the first column.
Yes.
Of the
First
table.
column is with a name, academic score, written score.
Serial number as in
Merit
the merit list.
Reading that page.
Serial number as in merit list.
Yes.
Merit list meant they were selected
Yes.
candidates. Now we are concerned about the waitlisted candidate. There are two aspects of the matter. If you cannot succeed, then the waitlisted candidate would be accommodated in the supernumerary post. But before allowing so, when the issue you are developing that the waitlisted candidates are also tainted, in your writ petition, is there any challenge to that?
Come. Let's give me 2 minutes, Milord. It is stated that, page 9, after the table, there are several candidates who have given blank OMR sheets, have been empaneled. It is further stated in the aforesaid selection process, merit has been compromised and appointments have been given in lieu of money. It is stated that in this regard that from order dated 20th September 2020, it has been found that the Central Bureau of Investigation has filed a report regarding the School Service Commission recruitment scam, which is now a concluded decision by the Supreme Court. Then paragraph 6 below the RTI, then kindly turn to paragraph 8. Your petitioner states that many of your petitioners have also tried obtaining information by availing the Right to Information Act and have got no propitious reply, and it gives opportunity to the concerned responding authorities to delay the process. It is stated in this regard that petitioners have already waited a long time, and without the intervention of the Honorable Court, petitioners shall be suffering irreparably. Your petitioner states that without having access to their original OMR sheets and tally it with the respective question booklet and answers, it is not possible for a petitioner to know that their OMR sheets have not been manipulated with it. Also stated in this regard that it is imperative that your petitioners get access to the original OMR sheets of the candidates who have been empaneled in the merit list and the waiting list, since there are many candidates in the empanel list who have very low academic score but have conveniently obtained disproportionately high marks in the written examination. And therefore, given the plethora of discrepancies and the responding authorities have already been held accountable for, your petitioners cannot be absolutely sure without scrutinizing OMR sheets. Then kindly come to paragraph 12. Then we petitioners state that to your utter shock, they found that the responding authorities by an order dated so-and-so created 1,600 supernumerary posts of assistant teachers with breakup of so-and-so, all for absorbing wait-listed candidates. But this is a very important aspect of the deliberate glaring violation of the rules and the constitutional provision. The aforesaid notification is absolutely arbitrary, unjust, and not tenable in the eye of law, inasmuch as the respondent authorities have no authority under the law to create supernumerary posts absorbing all waitlisted candidates. Be it stated that such action of the respondent authority is nothing but a big scam to cover up the corruption in the selection process, and as such the responding authorities have no authority and the jurisdiction to create supernumerary posts. Therefore, these fundamental things are there. I am not repeating.
No, there are two aspects of the matter. You may throw a direct challenge to the authority or the capacity of the state to create such posts. The purpose to absorb the waitlisted candidate. I want to know from you to correlate with the observation or the finding of the CBI charge sheet. Is there any allegation in the writ petition that the waitlisted candidates are also tainted?
No, I have said so. I think once again, I read the paragraph which I have read out.
Paragraph 12 is the capacity or the authority of the state.
No, paragraph 5. I started from reading from paragraph 5.
That is, they have been given appointment.
Yes, no, and with the several candidates, paragraph 5 will not continuing. It is stated that several candidates who have been given blank OMR sheets have been empaneled. It is further stated that in the aforesaid selection process, merit has been compromised. But from my end, I could not get any better bill or information because RTI information have been refused to me.
So your challenge is the entire thing. Those who are in merit listed and wait listed, both cases,
Both.
there was merit was compromised. And this is your general challenge.
And to cover up this misdeed, since people were agitating, government took a decision that we will create posts for them. Let them be given the cake, they will be silent. That was the whole game plan. And that will be operated from the agenda of the cabinet.
So this charge sheet of the CBI is in evidence in aid of your this
That's the point.
that you want to bring in.
Why not?
And
my lord
according
will be
to you,
pleased to, if love to show blood feels, direct the CBI counsel to produce the entire record before lordship with regard